Paul.
Thank you.
Ms. Padalano?
Good morning, Your Honors. Donna Padalano on behalf of the Commonwealth. If any of the three cases before you this morning demonstrates how out of control bail revocation is in the district court, this case certainly is the primary example. In this case, there was, I use words from the Chief Justice, it was willy-nilly. The clerk here was the one who actually took an action that, in effect, vacated the bail revocation order here. And so that's why we took the 211-3 in order to get some clarity.
But it was not, I take it was not deliberate. The clerk didn't know where this guy came from.
Right. Oh, this woman came from, exactly. And that's one of the issues, too. She was not aware, apparently, that there had been a bail revocation order.
Well, I have a question that even goes back before that, and I'm wondering if we have the whole story here because of that. If as far as the Roxbury District Court knew, this guy had made bail and he was on the street.
Right.
So why was a minimus issued from the why did a minimus issue?
Well, one of the things as I was reviewing that sparked my interest is there are two bail orders, the underlying charge, which was $250, and the second charge, at which time the bail was revoked on the first charge, but the second bail order was for $1,000. And when she was released on June 16th, apparently she was in contempt of the Dorchester bail order that was set. She never posted bail for the Dorchester case, only for the Roxbury case. So again, this demonstrates how things are not being kept orderly between the two courts, and how, you know, perhaps it's just that they need clarification and it's not done on purpose, but, you know, if it walks like a duck and talks like a duck and quacks like a duck.
But why did the Roxbury Court issue a minimus on June 3rd when, as far as the Roxbury Court knew, she was out on bail?
Right.
Why?
It's not clear. Apparently, one of the reasons why was to review the bail order. That's what the specialist.
But they would send a summons. She would. The Roxbury Court records reflected she made her $250 bail. She's on the street. Why did they issue a minimus?
It was issued before that point, I believe, and I'd have to check.
Before
that.
she had made bail?
Yes. She didn't make bail until June 10th, and the Roxbury minimus was issued on June 3rd.
Oh, okay. All right. Thank you.
So I believe that's why.
So the clerk, actually, it was the clerk that raised the bail?
Well, she had to instate a bail order because there had been bail revocation, although she apparently didn't understand that there had been a bail revoked in this instance. So she set bail, issued a bail order that mirrored the original conditions, and then the defendant posted bail a few days later. And this was only 8 days after the bail was revoked because of the second charge.
But the original bail was $250
Yes.
in Court A.
Yes.
Court B revokes that bail.
Yes. And sets a new bail of
The defendant
$1,000.
mysteriously reappears. The
Yes.
sheriff delivers the person back to Court A.
Yes.
And the clerk of Court A set bail in the amount of $1,000.
Yes. According to the...
Why don't judges set the bail over in that court?
That's a very good question. And according to the stipulated facts, she wasn't aware that she was doing what she was doing. I'm not quite sure how that works.
Ms. Padalano, let me just ask you a couple of questions. The statute is somewhat in the disjunctive. The court may revoke bail. So first, you've got may or may not revoke bail.
Right.
And may order said person held without bail. What that at least might suggest is you may revoke the first bail and increase the bail.
Yes. And that would
so
be...
doesn't that tend to go to whether or not the first bail continues or not? In other words,
It would if the bail hadn't been revoked. Certainly they can use the changed circumstances language from paragraph 6, which applies to bail orders, in order to increase the bail.
let me ask you the next question. Then the next sentence says The hearing shall be held upon the person's first appearance before the court before which the person is charged with committing an offense while on release, pending adjudication of a prior charge. So what does that mean? Which hearing?
I'm sorry?
The hearing shall be held upon the person's first appearance before the court.
The court who has jurisdiction on the second charge, I believe, is what that is saying, as opposed to the prior charge.
Right, so it's the revocation.
Right, that's right,
It's
the
before the
revocation.
court
Yes.
for which the defendant is
That's right.
brought
For
on
the
the
new
second
charge,
charge,
yes.
which triggers the
That's
revocation
right.
statute.
For simplicity purpose, charge B.
Yeah.
Exactly.
By the way, is the defendant still on bail in the Dorchester case here?
I think that the defendant is in contempt of her bail order in the Dorchester case here. The docket, as it appears in this, in the Commonwealth's brief, is from September of last year. And at that point, the docket, which is at the Commonwealth's Record Appendix, page 4, simply says that the defendant is out on bail. Doesn't say the defendant posted bail on the second charge. It merely says the defendant is out on bail. And I'm not quite sure how to interpret that.
And one more question. I suppose I should, what was the basis for asking the Dorchester court to send the case back to Roxbury? I mean, how could that have happened?
One of the issues that the Commonwealth brings up in its brief is that often when these issues are addressed, the assistant district attorney is not present when the minimus is addressed. It's a discussion between the clerk and the defense attorney, and often the judge and the assistant district attorney are not present during those discussions. In this particular case, it appears as if the defense attorney asked that the defendant be returned back to the original court for a bail hearing, or I apologize. Let me just see exactly what it says in the stipulated facts. In any case, no bail hearing did happen on June 3rd when she was returned.
No, I know, but I don't understand how the clerk could say, okay, I'll send the case back to the Roxbury court.
Right. The minimus was not signed by a judge. It was only signed by, has, I believe, Judge Hanlon's name typed into it. It was only signed by a clerk. So it appears as if it was a clerk who did issue that minimus.
So are you suggesting that we should put something into the opinion that cases shouldn't? But if clerks routinely handle these matters of when a minimus issues, and we say, no, clerk, you can't do that anymore, it's got to be done by a judge, are we going to be adding to the burdens of the district court judge immeasurably?
Well, that's one of the reasons why it's important for, I believe you would be adding to the judges, but it's one of the reasons why the Commonwealth is advocating that the bail revocation does not have a self-limiting time period. That bail revocation is essentially...
What do you mean it doesn't have a self-limiting time?
Well, it has the 60 days, it has nothing less.
As the statute requires.
But the judge is
What
not
about-
empowered to impose a lesser term of revocation. That's your
Exactly.
position.
And in one instance, for example, that also brings up the idea that it could be a punishment as opposed to what it is supposed to be, assuring that the defendant appears before the court to get on this fast track for trial for
But
the underlying charge.
I don't understand that, because we've just heard, with admirable candor, that cases are not going to be reached within 60 days, which, in my mind, raises the question as to why the Commonwealth proceeds under 58 rather than 58A. If you're proceeding under 58A, if there's somebody seriously endangers the community, you can take into account that they are in contempt of their bail orders.
Mm-hmm.
I mean, what are we doing with 58 if, in fact, we know beforehand that, with rare exception, these cases, in either case, A or B, first or second, is not going to be reached for trial within 60 days?
Well, there's a likelihood, quite honestly, that it's not going to be reached in 90 days either, as is required under 58A. So we run into the same problem with both statutes, and that's why the Commonwealth is also advocating that the end of the 60-day or the 90-day period, that there be a new bail hearing.
Well, I've always wondered why the Commonwealth goes through these hoops and goes either through 58A or through this 60-day revocation, when if you have a good case, you just don't ask for a very high bail to begin with, and that just continues through the life of the case. I mean, if you have a good case to make for bail.
Right. So
Why
you
isn't
have
it
a
much
higher
simpler
bail
for the
on-
Commonwealth to go in instead of going and getting a 60-day order, which is going to
Right.
expire? 60 days is no time in the criminal system these days. Why doesn't the Commonwealth just routinely go in and ask for a very high bail,
Well, we
setting
did.
forth all these factors?
Absolutely, we did in this case. The second charge did have a higher bail. We did have a high bail, but if we have clerks issuing orders, of bail orders, who aren't even aware that bail was revoked just 8 days beforehand, then that high bail was of no help in
That's a
this.
What's your
huge-
position? What's your position on the clerks setting the bails? Do you think we should say that they can't do that?
I believe it
Don't
should.
judges delegate that sometimes in a busy court like Dorchester or Roxbury?
I'm not sure, Your Honor. I think that in instances for bail orders, it should be reviewed by the judge, particularly when there is an underlying charge that also has to be considered. There are just many more factors, and we also have asked that.
Well, that's going to put a huge burden. In Suffolk Superior Court, for instance, the magistrate sets the bail routinely. Routinely.
Yes, for a single bail issue. But when we're talking about a bail revocation case, we're also asking that they follow the statute and issue written findings.
Well, are you suggesting that clerks issue bail revocation orders?
No,
they
absolutely
don't. So
not.
that's not an issue.
If it's a single, standalone case, this is the first crime, there is no other bail order, then perhaps that's the appropriate case for a clerk to hear a bail, to set bail.
Whose
But-
obligation is it to bring to the clerk's attention? Let's say the clerk is the district court clerk in Hampshire or Hampden or Barnstable or Superior Court, doesn't make any difference. Whose obligation is it to bring to that clerk's attention that this is not the first bail case?
Well, I would assume that the assistant district attorney is going to run, a record on this defendant to make sure that there are no outstanding charges. So that I believe that would be part of the duty of the assistant district attorney. Part of the problem, though.
Maybe I misunderstood you, but I heard you at least imply some kind of criticism for what this clerk had done because there had been a bail revocation 8 days before. How is the clerk to know that?
Yes, exactly. Well, and one of the problems in this case is that no one even told the Commonwealth that the defendant was in the court. There was no court case set for the defendant for this day. The defense attorney did not show up, and at the end of the day, the clerk said, I have someone in the holding cell. What do I do with this person? Let me just do what the last judge did in this court, in this jurisdiction, and set bail for exactly the same order, instead of notifying the Commonwealth.
Well, the problem was the clerk didn't look up the probation record. So if anyone had looked up the probation record, they would have seen the
And notify the
revocation.
assistant district attorney who is in the courthouse every day.
Yeah, I mean, there's so much of this is the parts of the system not effectively, timely communicating with each
Yes.
other. This is a perfect example of that. Apparently, defense counsel and clerk discussed the minimus. Defense counsel asked that the fellow be sent back to Roxbury where he can, in essence, have this revocation order reviewed for a date that's convenient on his calendar.
Right.
The DA is never notified. The defendant shows up. Defense counsel doesn't show up. DA doesn't have any idea what's going on here. The
Exactly.
court clerk has no idea what's going on here. The order that she has, or he has, says that they're to be held without bail until June 3rd, which is the day they're there. Then there's no bail order in effect. So all of this is a communication. In
Yes.
addition to whatever statutory interpretation is appropriate, it's a communication problem.
And doesn't this go on all across the state where a clerk is setting the bails?
I believe so. And one of the interesting things about this case, before we understood that it was the clerk who had, in essence, vacated the bail revocation order here, I had argued exactly the same scenario to Justice Spina sitting as a single justice 12 months beforehand. And that was one of the reasons why we said, please report this to the full bench so we can get some clarity.
In essence, could you just explain what you mean in essence? I mean, what is it that we're telling clerks that they are doing that is wrong in some kind of way?
I'm sorry, Your Honor. When I argued the case to Justice Spina sitting as the single justice, it was a judge and not a clerk.
This is not a clerk's problem, I don't think. The facts
No.
of this case are quite
But
bizarre,
you just said
but
that
this is
the
not a
clerk
clerk's
here,
problem.
in essence, revoked the bail.
Yes, but she didn't intend to revoke the bail.
But why was it even in essence, revocation of the bail?
I'm sorry, she didn't intend to vacate the bail revocation here when she issued a new
Because she
bail
said bail
order.
again at $250.
No, I understand.
She said the bail again.
But here there was
I misspoke.
There was a lack of communication as to what had happened earlier in a different court.
Right, and apparently there wasn't even a sitting judge that day, so it wasn't as if the clerk could run it by someone.
Did the defense attorney perhaps do something that he or she shouldn't have done, asking the clerk in Dorchester to send the case back to Roxbury? Is that really the basis of the problem? The defense attorney shouldn't have asked
It certainly
to have
could
a
have
case
been.
sent back for a day for no purpose.
If what, is stipulated to is, in fact, is the case before this court, that they did ask for it to be sent back for a bail hearing, when the bail revocation order is final. That is clear. The bail revocation order is final. So there can be no review by sending it back to the original court.
So that will solve that problem. They won't be,
Yes.
that will at least get rid of this case or any similar case. Defense
Right, that
attorneys.
they're using the minimus in order to make a more efficient bail revocation with the expiring dates on the bail revocation. And that's why we say there should be no date on the bail revocation order. It should be the statute that controls.
So if we say bail
up to 60
revocation orders are
days.
only for 60 days, then defense attorneys couldn't possibly ask for it to be sent back to another court for a
Exactly.
review.
If there are no further questions,
Thank you, Ms. Padalona.
thank you.
Mr. Lieber?
Good morning. David Lieber, Assistant Attorney General. Before I started, I just wanted to make clear that the Roxbury clerk didn't increase the bail to $1,000. The $1,000 was the Dorchester bail in the new case.
Okay, were you the defense attorney below?
No, I'm sorry.
Attorney General.
I'm representing
Oh, I'm sorry.
the,
Okay,
the
all right.
court.
Yeah,
The
okay.
defense attorney below didn't file a brief here.
I take it the clerks have authority to do what they were doing in these cases. Does that flow from statute, a rule?
That's actually not the case, at least in the Roxbury court. And it wasn't stipulated that the order sending the defendant back to Roxbury was outside the presence of the district attorney. That's not clear from the record. In terms of what happened in the Roxbury court, there is a policy, and it's now been enforced, that when a defendant comes in custody, they have to come before a judge to have a resolution of why they're in custody before they're re-released on bail. And that would have, if the policy had been observed here, that presumably would have taken care of the problem in that the ADA would have been aware that the person had come back in custody.
Apart from this case, if they come in not in custody, I take it clerks can set bail?
As an initial matter under the statute,
Yes.
that's correct.
It's statutory.
Absolutely.
Okay.
On arraignment, you mean initial matter?
That's right.
At any other time?
After arrest, prior to arraignment.
Right, after arrest. I'm sorry.
But not after the arraignment?
That's correct. And I don't.
Before the judge.
Yeah. Now, was the person who set the bail in this case a clerk magistrate or a clerk?
It was a judge in both instances. Now, in terms of the initial bail was Judge Leary, then it went to Dorchester, was revoked, came back. The clerk issued the minimus, which the clerk believed to be in accordance with the court's previous order of $250 bail, and that was a clerk who issued that.
But it wasn't a clerk magistrate?
That's correct.
Okay.
But it wasn't intended.
Clerks don't have the authority to set bail. Only clerk magistrates do, I take it.
I believe the statute provides that clerks of the district court initially have the authority to
Was
issue
this
bail.
like a clerical person that did this, made this mistake? Or was it somebody that actually had the authority to set bail?
No, I believe it was a clerical person.
I think it was the first assistant clerk. That's what the brief said.
Magistrates, I think.
I don't know the answer.
Are they all magistrates? Or
I'm
is it
sorry,
the-
I
Or is
don't
the
know
clerk
the
the
answer.
magistrate and everybody else is just a clerk? And,
Mr. Lee,
don't worry about it.
I'm sorry.
I have your brief. Could you just take a look at Exhibit 4? Which where the Commonwealth's motion for revocation of the defendant's bail is hereby allowed. Do you see that?
Yes.
Whose signature is that?
I believe that it's the judge's signature, Judge Ronquillo,
Okay.
in the Dorchester
Okay.
District Court.
Okay, thank you.
I don't know that I have much to add on the other questions, other than
Well, it's the Attorney General's position, as I understand it. A is that the order can be for less than, you make a quite cogent argument that it can be for less than 60 days, right?
That's right, based on Paquette and based on the statutory language. And I do hope that the...
But then don't we run into all the problems? You've been here this morning, and don't we run into all the problems that we're seeing? Whereas if we say it's 60 days, then you're not going to run into all these problems.
It's not clear that that would solve the problem. It's entirely possible, for instance...
No, it won't get the cases tried any faster, but at least you won't get...
But this could have happened, I'm sorry, the problem that occurred here could have happened if
No,
instead,
because they wouldn't go back to the, Roxbury Court wouldn't have had a chance to act on the bail. It would have been for 60 days, and Roxbury would, hopefully would have known. Nobody could have sent him back to Roxbury,
Well,
hopefully.
with respect, the court could indeed have sent the defendant back to the Roxbury Court for the purpose of rescheduling the trial.
Defense attorney couldn't ask that. Defense attorney couldn't ask that. If we say that a bail order, once revoked, is in effect for 60 days, the defense attorney would be in violation of our case if he or she went up and asked the clerk to send a minimus.
But to ask to have the trial moved up in accordance with the bail revocation, to have it done within 60 days. I mean, the defendant could have been sent back to the Roxbury Court for any reason, and the fact that the Roxbury clerk wasn't aware of why the person was there, this error could have happened in any case.
But then, I'm very sorry, if Judge Cowan is right, what does the language in the statute mean when it says not to exceed 60 days?
Not to exceed 60 days means either the court may or may not revoke the bail and may revoke it for a period up to 60 days, but it doesn't have to be exactly 60 days.
That's your position, right?
Yes, Judge.
And that seems to, well, never mind that, but again, whether one gets to the end of 60 days, and I'm trying to here understand whether this has been treated as an easier way to get a 58A. At the end of 60 days, or under the Attorney General's view, at the end of 45 days, or at the end of whatever it is, what then happens?
The court, with jurisdiction over the pending criminal charges, has authority to set new bail.
You say pending criminal charges. Two different courts have jurisdiction over this Court A, the original court, and then this Court B.
The pending criminal charges as to which the bail relates.
The revoked
revocation?
bail relates.
So
that would be the first court, the original
Yes.
court. So you agree with the district attorney then in the last case who said it goes back to the original court?
That's the rule that makes the most sense. The statute seems to provide very broad authority for district courts and superior courts to grant bail, and it's not clear that the statute compels that result, but that would certainly seem to be the most efficient way. Otherwise, again, you would have a situation where the original court is sending the defendant back to the revocation court for further action on a case that court doesn't have jurisdiction over, with all of the dangers that we've seen illustrated in this case.
So what happens between 60 days and however many days it takes to actually get a defendant back to the original court to set bail? What is his bail status in the interim, after 60 days and before the new bail hearing?
Well, I think that the defendant has a right to demand a bail hearing on the 60th day.
And if he doesn't demand it, then his revoked bail status will continue.
That's right, but he would have recourse to, presumably, this court in the last resort, but that would be clear.
But shouldn't it be automatic? Wouldn't it be much better if the judge revoking the bail says, bail revoked, defendant to be brought before the original court on day either 60 or 61, whatever it has to be?
That's right. That would be
so then,
an entirely
there's no
permissible
reason to
solution.
burden the defendant. There's no reason to burden the defendant or to burden anybody. It just would be automatic. we would be complying with the statute.
That's right. The statute would certainly permit that result, and
Well, then, if a judge picks a day less than 60 days, on that date, less than 60 days,
yes.
When the bail, the revocation ceases, then what happens?
Same thing.
That's right, the same thing.
Back to the original court?
That would be certainly permitted by the statute, and that would probably be the best policy. The original court, again, has the inherent authority to set bail. They also have the statutory authority. And
where do you get that reading out of the statute which says the bail shall be revoked until the case is adjudicated, comma, or not more than 60 days, not to exceed 60 days?
The statute says, the revocation court may order that the bail be revoked and may order that the defendant be held without bail pending adjudication for a period not to exceed 60 days.
Right, pending adjudication, provided that the adjudication is no more than 60 days.
Well, and I agree that that's a possible reading of the statute. Given what this Court has said about Section 58 in similar contexts, the purpose of the statute is to encourage release on bail, not to
But was that
deny.
the purpose of this addition to the statute, given the governor's message?
In Paquette, I mean, that's the portion of the statute that the Court is talking about, and it reiterates that that's the purpose of the statute. And again, the Court in Paquette conceives of this provision as a limitation on the bail court's inherent authority to revoke for failure to comply with the court's orders. So,
Mr. Lieber, let me ask you this. This is not exactly a new statute, correct?
that's correct.
Is there any reason why there's suddenly a sort of plethora of these cases, chaos? I mean, have we been living with chaos for a quarter of a century?
I'm sorry, I don't know the answer to that. This has been the Suffolk District Attorney's Office that has decided to pursue those here. It's not clear to me why it would have become a bigger problem now than it was before. I don't know the answer to that.
Well, each of these cases presents a wonderful sort of study in the failure of communication. So whatever's going on here is not what ought to be going on here.
But I can't think that our communications are any better given unless somebody's not communicating with somebody where they used to communicate before. I mean, I don't know whether it was Ms. Padalano or who said, somebody can pull up criminal records which are now in a database. I mean, I'm not sure that was available 25 years ago. I mean, perhaps I should have asked, somebody from the, from one of the district attorney's offices, but it's not quite clear to me why, after this long passage of time, there's suddenly, quote, chaos, unquote.
Well, I do think it comes as a follow-on to the Court's earlier decisions in Delaney and Perez, which kind of limited.
Delaney is not a recent case.
That the last 10 years. That's true, but I think it's been a development in the idea that there should be, at least from the district attorney's point of view, there should be limited review of these kinds of issues.
Thank you,
Thank you.
Mr. Lieber.